जांच में कर्नल अश्विनी कुमार को विभिन्न बिंदुओं पर दोषी पाया गया है.
Absolutely none, my lord. I am a decorated soldier. I was appointed here.
Allegation is regarding siphoning of funds of the ex-serviceman welfare fund. He was posted as assistant director in the directorate of the Sainik welfare.
When did you terminate his services? 21st?
January 2020. कर्नल अश्विनी कुमार सैनिक कल्याण में सहायक संचालक के पद पर संविदा नियुक्ति प्रदान की गई थी. कर्नल अश्विनी कुमार के कार्यकाल के दौरान मध्य प्रदेश भूतपूर्व सैनिक कल्याण समिति में आर्थिक अनियमितताएं उजागर हुई हैं. Filed on behalf of the state, the delay is 19 days.
Yes. Yes.
Your Lordship, we are aggrieved by the order passed by the Honorable Single Judge quashing the termination order on the ground that there is violation of principles of natural justice. Your Lordship, the respondent.
What allegation?
Allegation is regarding siphoning of funds of the ex-serviceman welfare fund by the assistant director, who is the respondent. He was posted as assistant director in the directorate of the Sainik welfare. His appointment, in fact, Your Lordship, was purely contractual in nature.
Are you ready or you will take notice?
I am ready.
His appointment, Your Lordship, was purely contractual in nature. A show cause notice was issued to him, which is Annexure P2 at page 14 on 23/12/2019. That the funds from the ex-serviceman welfare funds have been siphoned off by collusion of the respondent and the other persons in the department, in the directorate. Now, a preliminary inquiry was also held prior to that, Your Lordship, that we have filed as Annexure R1 at page 4. That was dated 18/10/2019. We've also stated in the return, Your Lordship, that an FIR has been lodged against, with regard to the embezzlement of funds with the EOW. Your Lordship, the Honorable Single Judge, Your Lordship, may kindly come to the order.
1 second. When did you terminate his services?
21st of January 2020.
21st?
January 2020.
When did he attain superannuation?
In fact, Your Lordship, he has not attained the age of superannuation.
When did he become 60 years?
He is yet to become
He's yet
60.
to-
That's an in fact wrong.
Not been retired.
But here he says already achieved age of superannuation.
No.
Who appears to have already attained. This is correct.
Appearance means what? Where did he get appearance from?
From the age, from the cause title. 62 years की एज है यहाँ.
Yeah, we issued a show cause notice.
We issued him.
Inquiry was held.
No inquiry was.
Inquiry was conducted prior to the issuance of the show cause.
After show cause notice was issued, did you hold inquiry?
No, it was not after. Yes, in fact, that is on that ground. In fact, Your Lordship, the
Where is the order of termination?
So that is Annexure P6 at page 31.
What does it say?
May I read to you? विभागीय आदेश क्रमांक सो दिनांक 3 नवंबर 2016 द्वारा कर्नल अश्विनी कुमार को संचालनालय सैनिक कल्याण में सहायक संचालक के पद पर संविदा नियुक्ति प्रदान की गई थी। कर्नल अश्विनी कुमार के कार्यकाल के दौरान मध्य प्रदेश भूतपूर्व सैनिक कल्याण समिति में आर्थिक अनियमितताएं उजागर हुई हैं। विषय पर जांच समिति द्वारा की गई जांच में कर्नल अश्विनी कुमार को विभिन्न बिंदुओं पर दोषी पाया गया है एवं उनकी लापरवाही प्रकट हुई है। उक्त अनियमितताओं के लिए कर्नल अश्विनी
Yes, sir.
Should, without an inquiry, they could not. It's an order which is casting stigma on me. The so-called inquiry behind the back, that was on the complaint of an ex-officer complaining that some irregularities are going on. I was there at that point of assistant in the directorate, assistant director in the directorate, this thing. I fully cooperated. In fact, I am the one who lodged the FIR against these. My lord, may kindly see the FIR which they have enclosed. I am the complainant in the FIR. If my lord may come to R2, the return, page 60.
Is lodged against you.
No, I am complainant. FIR is lodged against the ex-Havaldar who was keeping the record. It was never brought to my notice that a parallel account is being run. And it's only after the complaint of Colonel Manoj Jain that I found about it and lodged an FIR against him. यह एफआईआर में शिकायतकर्ता नरेंद्र गायकवाड़ और कर्नल अश्विनी कुमार सेवानिवृत्त।
In fact, Your Lordship, the inquiry report, Your Lordship, we have filed as annexure R1 at page 4.
Via
Yes.
the pending adjudication. Who's
That-
the complainant?
That, Your Lordship, is at annexure R2 at page
16.
16.
Relevant is at page 7.
Complainant is Abhiyogi Suchnakarta Krupa Shankar Singh.
No. He is the officer who received this written complaint that I submitted. You come to page 17, paragraph 2. आवेदन पत्र की जांच के संबंध में संचालनालय सैनिक कल्याण शाखा सो एंड सो भविष्य निधि आयोग सो एंड सो दस्तावेज प्राप्त शिकायतकर्ता नरेंद्र गायकवाड़ व कर्नल अश्विनी कुमार, मैं शिकायत करता हूं, तथा गवाह कर्नल SR पिल्ले, कैप्टन जोसेफ, कर्नल उदय सिंह, सचिव से मध्य प्रदेश सो एंड सो तेज सिंह, समिति क्लर्क सुश्री रुचि पांड्या सो एंड सो के कथन दर्ज किए गए। मैं शिकायत करता हूं। Absolutely none, my lord. I am a decorated soldier. I was appointed here. And I am the one who unearthed this scam, and I am sought to be framed in order to save superior officers. I am the one who, this was going on for quite some years. When I came in, this account was just kept out of the radar totally. It was when Colonel Jain put up this complaint to the committee and a copy was marked me that I started inquiring about it. I also inquired from Bhavishya Nidhi Ayog where the money has to go, because you have issued a certificate in favor of this organization that we are working, this thing, whether you issued the certificate or not.
Lordship, that liberty, Your Lordship, may kindly see. If I may first refer to Your Lordship, the question that was posed before the question of liberty being granted. Paragraph 22 of the inquiry report at page 9 is seen, Your Lordship. The role of the petitioner is
That is an in-house inquiry.
Prior to issuance of show cause.
Thank you, Lordship. The liberty that is granted, if I may read that portion, since the quashment as opposed is only on technical ground and not on merit, the employer is at liberty to pass fresh order after complying with the due process as explained above. Now, as explained above, Your Lordship may kindly come to page 18, paragraph 5.3. Now, relying on the case of Khemchand versus Union of India, where the procedure has been provided as to what would be the reasonable opportunity in such cases prior to termination.
We'll allow you to proceed from the stage of reply to show cause.
Because
He has given his reply.
yes, given.
Start from that stage.
Since he's a contractual employee,
No.
the all the procedure in respect of cross examination and that detailed inquiry is not contemplated in cases of
Whatever it
contractual.
is, you have to go through that. We'll say from the stage of receiving the reply to show cause notice, you proceed in
You have the liberty to proceed.
whatever
Always.
the law is, you proceed.
If I may only point out, Your Lordship, passed by the Honorable Court in the case of State Bank of India versus S.N. Goel, 2008, volume 8, SEC, page 92. And paragraph 17, Your Lordship. In respect of enforcement of a contract of personal service, because this would where the relationship of master and servant is purely contractual. It is well settled that a contract of personal service is not specifically enforceable, having regard.
Yeah, agree with that. It can't be stigmatic. You sack him with one sentence. Who's stopping you? But you having given him a show cause notice, you have to take it to that end. There is no need to give him a show cause notice also because it's contractual.
Yes.
You can't play both principles.
That is, if I may read the paragraph.
We are aware of this. We are not. We are in
Even
tune
if
with
it is
that.
found to be illegal or breach of contract, or then it may not
Then
be.
you say so. That is not what you say. You make a heap of allegations against him and terminate him. Therefore, it is said that it is stigmatic.
So far as these relying on Khemchand versus Union of India, that is distinguishable because that is
We clarify.
in case
Well,
of a
before
government
that clarification, there's a statutory provision that even for us, my lord, these CCS rules will apply. Here it is, my lord, 3(1)(c). CCS CCA rule. There's no question of Khemchand. Even otherwise, you are duty bound to follow Rule 14. Respond. 1.
Or two.
2 was the complainant whose original complaint, Colonel Manoj.
No party.
Initially, because it was on his complaint, my lord, everything had. Formal party can be treated.
The list is between the appellant and respondent number 1. We do not find it necessary to issue notice to alter. The reason assigned delay in filing the appeal is conducted. The writ petitioner questioned the order of termination by filing the instant writ petition. When a single judge came to the view that the order of termination is stigmatic and hence quashed the order of termination by granting liberty to the employer to pass a fresh order in terms of the findings recorded there and imposed a cost of 5,000. Questioning the same, the state is an appeal. The transfer has been condemned or the past one single judge that the writ petitioner, being a contractual employee, is liable to be terminated at any point of time. That the single judge committed an error in interfering in the orders of termination. The same is disputed by Sri Sansolan and senior counsel appearing for the counsel representing our hearing level counsels were to view that appropriate interference is fault. On considering the order of termination, we are of the considered view that the findings recorded by the learned single judge appears to be just and appropriate. The order in our considered view is stigmatic Therefore, even if he is a contractual employer, such an order could not have been passed until and unless a full-fledged inquiry is held against the charge. Admittedly, a show cause notice was issued to him to explain his conduct. After the reply was filed, the order of termination has been passed without holding an inquiry. The same is contested by the counsel for the state on the ground that an in-house inquiry was held wherein the guilt of the petitioner was proved. However, we agree that such an inquiry does not satisfy the requirements of law. Having issued a show cause notice in order that the petitioner explains himself, a full-fledged inquiry requires to be held against the petitioner. They having not done so and the order being stigmatic, we do not find any ground to interfere with the order passed by the learned single judge, except to the extent that the appellant is at liberty to proceed from the stage when the writ petitioner has submitted his reply to the show cause notice. The rest of the procedure will be in accordance with law. The cost imposed by the learned single judge on the appellant is set aside. We dispose of it.
They've already paid, I
We had
believe.
already deposited the. That-
Submitted that since the cost has been deposited, the best way to refund the same to the appellant.
अपने को दे दिया. The cost was paid to us.
How we can get
So that was the order passed by the.
get so emotional about these.
Was the order passed by the honorable.
Not fair.
Hello?
Not fair.
No, we can return it. I mean, obviously, but we'll return it. But the point is, well, at least we are entitled to cost. It's such a blatant inquiry. They kept on, my lord. It's totally out of.
Not. But it's just every day. You can't go on imposing costs like that. Costs that have been directed to be refunded.
In the meanwhile, my lord, because the order terminating me gets reinstated, my other benefits, my lord, will be directed to given to me. I may be reinstated back, which they are not doing.
That since order of termination has been set aside, the consequential would follow.
That.
Huh? But anyway, is entitled to.
Yes.
to get it.